Good evening, everyone. Welcome once again on Legal Hour, Legal Time with Connaughts. As you know, in this program, we bring recent immigration issues, we discuss it and share it with you. We share our knowledge with you on immigration matters. We also take your live questions. So, if you have any question regarding any immigration issue, please make sure you send your question directly to us live on Facebook, and we'll be happy to answer. Today we have with us again Sharia Khan after a long break. How are you, Sharia?
Very good, thank you so much.
Just to update you, Sharia is our head of immigration, and he was on a break. Now he's joined us again, which is very good. So Sharia, starting with the recent article you have put on regarding Tier 1 General 3225 applications, do you want to comment on those?
Yes, well, just by way of background, there's been some good news yesterday for Tier 1 General HSMP migrants. And as many migrants would be aware, applications were being reduced, settlement applications were being refused by the Home Office on the grounds of tax discrepancies. The allegation was that the applicants had made a submission to the HMRC of one amount and whereas to the Home Office of another amount. So what has been happening since 2016, a number of applications have been refused on the grounds that this has been deception or this conduct is equal to something that amounts to matters of public concern and the persons are not of good character. So strong allegations made by the Home Office in refusing applications for settlement. And after this matter reached the Parliament, the Secretary of State, the Immigration Minister agreed to review all these matters. And what's happened following the review is that a new case instruction has been issued. And what that case instruction has now indicated is that all migrants must be interviewed. No application can be refused without interviewing the migrant first to determine what was the cause of the discrepancy. And number two, that a witness statement has to be obtained from the HMRC. Now, I think point one may not be such a good news because a lot of these migrants had actually already been interviewed. But point two is helpful in the sense that a witness statement is needed by an HMRC officer, and I believe this won't be the end of the story because the witness statement of course then shouldn't only confirm the discrepancy, which is not disputed, but also say something more, say something like this was at least deception or that those migrants have been penalized for this conduct. Because what we were at least arguing in cases, and by the way, by the latest statistics, about 2/3 of the appeals have been successful. So basically what that means is that roughly about 1,500 cases which were refused, 2/3 of these have been successful. So that means that the courts, the immigration courts or the administrative court is not accepting the Home Office's position on this matter. We don't know the position on the reasons why the 1/3 of the other matters were refused. But anyway, going back to that point, what has been happening is that we've been arguing in the appeals that even if there are discrepancies, there would be good reasons for their discrepancies and applicants should be asked before the Home Office prejudging the issue. And number two, what we've been suggesting is that even if there are discrepancies based on the instructions from our clients, what we understand is that there were genuine reasons such as the fault of an accountant or an administrative error in the submission of the accounts. These individuals were migrants, of course, and therefore they were not tax experts. So they were following advice from their accountants, or they were just using their own limited knowledge to submit these tax returns. And what we've seen in almost all of these cases is that the HMRC has happily accepted the amendments. What we've also seen in at least almost again all of the cases that the HMRC is not prosecuting these people, because if this really is deception, that the HMRC has unlimited powers to prosecute these people, to fine them a very high amount, but the HMRC is not doing that, which means that the HMRC office, which is also falling under the Home Office, is very happy with the explanation that is being given by these migrants. But the Home Office, because of the hostile environment created by Theresa May, is taking a much different staunch view of these, what we would say, administrative errors in many cases. Now, don't get me wrong, of course we agree that perhaps somewhere in these 1,500 cases there might possibly be a deception, but what we're arguing is legally that deception has not been established and the Home Office is playing it very smart. What they should do then is apply the relevant section which goes to deception. But what they're not doing is not applying that section, because then the burden of proof will switch and they will need to prove the deception. And because they know they can't prove the deception, they're just smartly applying 322.5. But of course, now that we've got the new instruction on 322.5, it might be good news, but it would be similar to the Windrush applicants, good news too late, because a lot of these matters have been decided as of last year. And I think very few appeals are now in the system. And I would say almost none of the applications or none of the applicants are still waiting for a decision. The immigration minister very smartly said that we are going to stop taking decisions on these applications. But what's the point? Because they've closed the route in 2016, nobody's making these applications, and all these applications have already been decided. But that said, what I was going to say is that this potentially may then be another breath of fresh air for possibly people who have lost these judicial reviews, if they didn't have a right of appeal, to re-argue that if they were not interviewed or if there was no witness statement from HMRC officer, then these matters need to be reopened. And of course, beyond that, for those people who are waiting for their appeals, they have many arguments from before. We have many precedents because between ourselves, we've won almost, again, all of the appeals. Judicial reviews, of course, get technical because they're not a finding of fact, and that's why it's better to have a right of appeal. So yeah, I mean, that was a bit of a small lecture on this point, but feel free to email us or contact us to discuss what this new guidance means for you.
Sure. Thank you very much, Sharia. My personal understanding in a lot of matters I have dealt with myself, and of course yourself as well, HMRC has actually fined them to an extent that they have filed their tax returns late, or they have made the amendments late. But that's a very minimal amount they are fined.
Correct.
Like you said, they've not been prosecuted, etc. So my understanding is that it's a very careful statement given by the Secretary of State, saying that just a statement from HMRC will be required. No further information is given as to what should be included in the statement itself. So statement of confirmation from HMRC stating that there are amendments made to the tax. This is something all the migrants would agree anyway.
Yes.
If they have made amendments, they wouldn't say that they haven't made amendments when they have.
Correct.
So it's again something which there's a lot of room still pending.
Yeah, I think, although as I said, I mean, this is good news, but this needs to be again explored by the courts to what this means, because a statement which just simply says there's a discrepancy doesn't take us anywhere, because almost, as you said, all migrants accept the discrepancy. It's the reasons, and that's why we need the HMRC to make a statement. And maybe, yes, if the HMRC officer is prepared to say that this is deception in their eyes, this amounts to a person who's not of good character, then fine, we've got a case that at least they have a uniformed position on these matters.
I mean, I was reading one of your articles where you have quoted from one of the decisions you recently received where judge has made some comments regarding that.
Correct.
If do you want to shed some light on?
Well, I'm forgetting the exact words right now, but it is correct that one of the appeals we recently won was where the judge said this is a clear example of cases where 322.5 should not be used. So basically, what they're trying to say is, and what all lawyers have been arguing, is that this section was originally intended for terrorism and people of seriously bad conduct. It was never meant to be used against professionals who've come into this country, who've contributed. I mean, fine, there's a dispute now as to what amount of tax they paid, but there's no dispute about the fact that they worked here and they contributed to the economy. So clearly, it's a question of using a sledgehammer against a fly, and that's why we believe legally this is a move in the right direction. Of course, the courts have been in our favor in at least 2/3 of these appeals. And that's why, again, I would say these matters, at least for applicants who lost these cases, or for applicants who did not have a right to appeal this matter, definitely is a breath of fresh air, and these matters perhaps may now be reconsidered.
Excellent. I mean, in the decisions, we see over and over again that Home Office argues that even if there is no dishonesty, migrants have benefited from their mistakes. And we see over and over again from the tribunal judges, their position is that just because they have benefited does not mean there is dishonesty involved in these type of matters.
Correct.
And it's very clear that a lot of people have suffered. Good news is that if you are one of those who had judicial review refused, did not have right to appeal, where fact-finding process could have been done properly, you can contact our offices, and we should be able to help you with these type of matters, see if we can do anything. Shira, moving on from these, we have had a lot of questions in the past few weeks. We have summarized those questions. One of the questions was regarding temporary admissions being granted by the Home Office. When someone makes an application under 10 years long residence, a lot of people had this misconception that if you don't have leave to remain, just have temporary admission granted by the Home Office, it's not included in your long residence, towards your long residence. But Home Office guidance is very clear, and we discussed it as last time, that this is something which can be used towards leave to remain. Okay. So is it something you think a lot of migrants should be exploring, in a sense that if they were on temporary admission, straight away or within 14 days after the leave expired, you should be going ahead and making application in the long residence and arguing that they should be granted leave to remain for the long stay or long residence stay in the UK?
Yes, I mean, this is a troublesome issue for many immigration applicants, and we are in the courts. We have recently made an application for a judicial review with this specific point. As you said, paragraph 339E allows you to make an application within 14 days. And when an applicant makes such an application, what the Home Office would do is that they would still consider the period from the point the applicant makes this application to the point where an application is successful in the future, or if it's a ZLR application, a long residence application, then the Home Office would consider that whole period still as a gap. So basically, what they're saying to you is that you can make an application, but at the same time that you cannot. So it's a confusing position. My view is then, if the Home Office's position is what they are taking out presently for 39E, then they should abolish it altogether and simply say you cannot make an application once your leave has expired. But if you introduce a provision, a grace provision which allows you to make an application within 14 days, then it should not be held against a migrant once he's paid a huge amount of fee for the Home Office to go around and make an application and say, you're not technically a person who's made an application in time, but at the same time, we won't consider you as an overstayer. So it becomes very difficult to even explain this situation to clients, because their simple point is, sir, we made an application within 14 days. Why are we being punished? What they don't appreciate is the operation of 3C. Now, 3C is an act of parliament, so it's very black and white. But where we have the Home Office's guidances and the immigration rules, that's where it gets confusing. So to answer Oasis' question in simple words, at least the position that's being taken by the Home Office is that when you're on temporary leave, when you've been granted immigration bail, when you made an application within 14 days, in all those positions you do not benefit from having leave. You're simply ex gratis just granted particular period of entry, or you're allowed to stay in the country, you're allowed to make an application, but it won't count towards lawful residence. And what we're trying to argue is that all of these amount to lawful residence, and if it amounts to lawful residence, then they should count towards long residence, it should count towards 10 years, it should not be considered a break in your residence. But we're working on this case. We are on the side of the applicants. We sympathize that there is something to be done here, and that's what we're working on.
Excellent. And just moving on from there, we also had a lot of questions regarding 7 years concession policy, where a child has lived in the UK for 7 years. But the questions particularly we had was, can parents of these children go on to the same day service? Now, my position generally in these type of matters is, if they don't have leave to remain, which they generally don't, then even though they can in theory go on to the same day service, but because of the long assessment process, a lot of times Home Office keeps these applications and don't give a decision on the same day. So they spend a lot of money, yet they don't get the decision on the same day. So it's a preferred option to go into the postal route.
That's correct.
But in theory they can go into the same day service. Do you have any preference with these type of?
No, I'm exactly of the same view as yourself. I find myself struggling to explain to clients as well, because unfortunately the stigma we suffer from is that there is some advertising or marketing where some firms would simply say that, they secured leave for their clients on the same day route under in this case under the 7-year route. But the danger is in the lack of information out there. So they don't tell us that maybe one of the children already have leave under the stateless provisions. Because to give you an example, if one of your children are already British because of the stateless provisions, or one of your children have already been granted leave because a separate application was made for them and then fine, the parents can go ahead and make this application, and we would encourage that. But where the entire family does not have leave, including the children who are covered by the 276 AD rules, the 7-year rule, then it doesn't make sense, for, as always said, that you should spend approximately 610 per application. So about, for a family of 4, you're spending about 2,400 pounds odd, and that application may potentially be then retained by the Home Office to do further checks. The reasons for this is that A, it's a human rights applications which is never considered simple by the Home Office. Then you don't have your passports. In most cases, I've always said that you don't have leave. So all these reasons are strong enough for the Home Office to retain your application for further checks, and you would lose out a good chunk of money. So we would suggest in such cases usually for a postal application to be submitted, but we're open to client's instructions. Of course, it makes no difference to us. If a client insists and is happy to pay on top what is required, then we are happy to submit such applications on the same day route.
Excellent, thank you, Sharia. And also, just moving on from there, coming back to point-based system.
I just wanted to read out the words by the judge because you asked.
Okay.
I just looked it up. So basically, this is again going back to the 322.5 tax discrepancies, and one of the appeals which has been successful last week. The judge says that whilst I've taken into account that the appellant stood potentially to gain from this error, that's what the Home Office is arguing, not every error that causes gain is necessarily dishonest. And I think this is just like such a perfect summation of the fact that if you benefit, it does not mean there's dishonesty. There could be good reasons.
Excellent. Coming to point-based system again, entrepreneur matters. I understand that you deal with a lot of super premium service matters as well.
Yes,
you just want to explain the process to our viewers. If they are on this type of visa and they want to go on to the premium service, what exactly do they have to do?
Okay, great. Yeah, yes, I do accept that there's not a lot of awareness about this route, but what I am pleased to inform our viewers is that we regularly offer super premium appointments to our clients, and what that means is that the Home Office comes to our office and they conduct the biometrics at our office. So there's no hassle of actually securing a slot on the premium service, which is almost impossible as I understand it, and doesn't really guarantee a decision on the day. With the super premium, you're guaranteed a decision within 5 days, and of course, as I said, it's quite convenient that because all the biometrics, all the post application questions come to us as the lawyers. And the other benefit, of course, of that is that tier 1 entrepreneurs who are not allowed to use the premium service can use this service. Previously, tier 1 entrepreneurs who were applying for settlement were not allowed to use this service. That service is now open for them as well. There is a high fee for this, but the good news in some cases is that fee can be shared. So a total of 4 different applicants can make an application on the day. Sometimes, of course, if an applicant requests and pays for one slot, then we can request the Home Office that other applicants are able to secure another slot on the same day by paying further fee. But as I said, that please get in touch if you're not able to secure premium service bookings. We might be able to help you by putting you onto the super premium, not at the high fee that's been quoted, because applicants are allowed to share this fee. I won't get into the details of the fee at this stage, but we'll explain it to you if you get in touch.
Excellent. Thank you very much, Sharia.
No, it's been a pleasure.
And I think that is all we have for this week. Just to mention that we have also started this program in other languages. For example, last week we conducted this program in Urdu, and we are planning to start this program in other languages as well. So any particular language you're interested in, please make sure email us, and if there is a demand, we will try and do these programs in different languages. At the moment it's English and Urdu. Alternatively, we're doing it every Friday. So feel free to email us, myself, Sharia, or any other of our team members if you have any questions, further inquiries, or you have any issues with any of the immigration matters. We'll be very happy to help. Once again, thank you very much, Sharia.
It's been a pleasure. It's been a pleasure. Thank you.
Thank you.